हेलो फ्रेंड्स, वेलकम यू ऑल इन सीक्वल क्लासेस। फ्रेंड्स, ये यूपीपीसीएस प्रीलिम्स का वीडियो सीरीज़ है। आज हम इस सीरीज़ में देखेंगे कि यूपीपीसीएस प्रीलिम्स में पिछले 5 सालों में पॉलिटी के दृष्टिकोण से कौन कौन से क्वेश्चंस पूछे गए। उन क्वेश्चंस का आंसर देखेंगे और उनसे रिलेटेड कुछ फैक्ट्स भी मैंने इस वीडियोज़ में कवर की हैं। इस पूरे डिस्कशन का PDF भी आपको मिल जाएगा। सो समय कम होने के कारण हम एक एक करके पॉइंट को डिस्कस नहीं करेंगे, लेकिन पूरा कंटेंट आपको एक PDF में मिल जाएगा। आप PDF डाउनलोड करके फर्दर उसको एक बार स्टडी कर सकते हैं। पहला क्वेश्चन देखेंगे, विच अमंग द फॉलोइंग प्रोविजंस पार्ट ऑफ द कॉन्स्टिट्यूशन इज नॉट करेक्टली मैच्ड। तो इसमें कौन सा प्रोविजन और पार्ट मैच नहीं है। एक तरफ प्रोविजन लिखा हुआ है, दूसरी तरफ पार्ट्स लिखे हुए हैं। द यूनियन टेरिटरीज दैट इज पार्ट 8 दैट इज करेक्ट। द शेड्यूल एंड ट्राइबल एरियाज पार्ट 10 दैट इज ऑल्सो करेक्ट। ट्रिब्यूनल्स इट इज रिटन पार्ट 11 दैट इज नॉट करेक्ट। ट्रिब्यूनल्स आर मेंशनड अंडर द पार्ट 14 A. Under part 11, there is a relationship between union and states. Official language that mentioned under part 17, that is also correct. This is the list of part and subject and their articles, so you can go through this. Now we'll move to next one. The Constitution of India initially permitted use of English language for all official purposes for a period of, answer is 15 years. So this is written under the article 343 of part 17, official language. You can read these articles. Next one, which of the following is not a part of Article 20 of the Constitution of India? So Article 20 में क्या है? Protection in respect of conviction for offences. Prohibition against self-incrimination, that is option A, that is correct. Double jeopardy clause, that is also correct. Ex post facto law, that is also correct. Prohibition against torture, ये mention नहीं है, so this is not correct. So that's why C is our answer. So here you can see, no person shall be prosecuted and punished for same offence more than once, that is double jeopardy clause. Then third clause is, no person accused of any offence shall be compelled to be a witness against himself, that is prohibition against self-incrimination. And here it is mentioned, no person shall be convicted for any offence except for violation of a law in force at the time of commission of the act. So that is ex post facto law clause. कुछ और आर्टिकल्स जो आसपास के हैं, 21st आर्टिकल दैट इज प्रोटेक्शन ऑफ लाइफ एंड पर्सनल लिबर्टी, 21st 1A राइट टू एजुकेशन, 22nd आर्टिकल प्रोटेक्शन अगेंस्ट अरेस्ट एंड डिटेंशन इन सर्टेन केसेस. Next question, which of the following statement is not true regarding Gram Sabha? It has the power and function at the village level like state legislature has at the state level. That is correct. Its powers are determined by the central government. That is not correct. It is determined by the legislative assembly of the state. So you can say it is determined by the state government, not the central government. It is a village assembly consisting of all registered voters in the area of the panchayat. That is correct. So this is mentioned under the part 9. The panchayat's definition is under article 243, and other provisions are like 243A, 243G. You can see the other related provisions. Next question, with reference of the election of Vice President of India, which is declared void by the Supreme Court of India, which of the following statement is correct? The acts done by him as Vice President before such declaration are considered valid. Yes. The act done by him as Vice President on the day of such declaration are not considered valid. No, on that day also it will consider valid. So this is not correct. So option A is correct. See, this is mentioned under Article 71, matter relating to or connected with the election of the President and Vice President. So under clause 2, if the election of the person as a President or Vice President is declared void by the Supreme Court, acts done by him in the exercise and performance of the powers and duties of the office of President or Vice President, as the case may be, or on or before the date of decision, on or before the date of decision of Supreme Court shall not be invalidated by the reason of that declaration. So उस declaration से जो भी एक्ट प्रेसिडेंट और वाइस प्रेसिडेंट ने उस दिन किया है या उससे पहले के दिन में किया है वो इनवैलिडेट नहीं होंगे. आई मीन दे विल बी वैलिड. 72nd आर्टिकल में मेंशन है, पावर ऑफ द प्रेसिडेंट टू ग्रांट पार्डन etc, टू सस्पेंड, रिमिट और कम्यूट सेंटेंसेस इन सर्टेन केसेस. नेक्स्ट वन, विद रेफरेंस टू द पोस्ट in the secretariat of the parliament, which of the following statement is correct? A common post may be created by the secretariat of each house of parliament. That is correct. The parliament has the right to regulate service condition of secretariat staff in either house of it. Yeah, both are correct. So here this is mentioned under article 98, secretariat of parliament. Each house of parliament shall have a separate secretarial staff, provided that nothing in this clause shall be construed as preventing the creation of posts common to both house of parliament. So common post can be created. Parliament may by law regulate recruitment and the condition of the services of the person appointed to the secretarial staff of either house of the parliament. So that is also correct. Next one, with reference to the Union Finance Commission, which of the following statement is correct? Finance Commission has chairman and 6 members. It submits its report to the Niti Aayog. So both are not correct. It has chairman and 4 finance commission, which shall consist of chairman and 4 other members to be appointed by the president. Under 280 under 280 article, finance commission is mentioned. So there will be a chairman and 4 members. And chairman, this finance commission submits its report to whom? It shall be duty of commission to make recommendation to the president. So जो भी इनके reports recommendation होते हैं वो president को submit करेंगे, ना कि नीति आयोग को. Next one, with reference to the Attorney General of India, which of the following statement is correct? A person is appointed as Attorney General who is qualified to be appointed as a judge of Supreme Court. Attorney General can be removed through the same process as the judges of the Supreme Court. No. So this is correct. This is not correct. So under Article 76 of Indian Constitution, Attorney Generals for India, that is mentioned. So President shall appoint a person who is qualified to be appointed as a judge of Supreme Court to be Attorney General for India. Now here it is written under clause 4, the Attorney General shall hold office during the pleasure of the President and shall have received such remuneration as the President may determine. So यहाँ President ही appoint कर रहा है, President ही remuneration भी decide कर रहा है और President can remove. No, so there is no fixed tenure. President can remove. So this is not correct. Attorney General can be removed through the same process as judges of the Supreme Court. No, judges of Supreme Court के केस में क्या होता है कि पार्लियामेंट में केस चलता है, पार्लियामेंट अप्रूवल होती है, then only President can remove. Given below are 2 statements. One is labeled as assertion and other as reason. The President can recommend the Parliament to change the boundary of any state after seeking view of the concerned legislature of that state on subject within a specified period. It is not mandatory for the President to accept the proposal of the concerned state. Yes, both are correct. Under Article 3, President can recommend for the change of the boundary, change of the name of the state. So these things President can recommend. उसके लिए जो concerned state है उसका view President can seek the view of the concerned states, but states का जो भी recommendation है, जो भी आपत्ति है या जो भी provisions है state के, वो it's upon to president कि वो उसे recommendation को accept करते हैं कि नहीं करते हैं. He can reject or he can accept. Now next one, given below 2 statements, one is labeled as assertion and other as reason. The president is a part of parliament. Yes, parliament के में कितनी चीजें आती हैं? 3 चीजें, लोकसभा, राज्यसभा and president. All bill passed by 2 houses of parliament cannot become a law without the assent of the president. That is also correct. So this reason is also correct. He is a part of parliament because without his assent, a bill cannot become the law. So that is also correct. So option A is correct here. The related article, the composition of parliament, that is under Article 79. Composition of Council of State, that is Article 80. Next one, with reference to the composition of Legislative Council in a state of India, which of the following statement is correct? In Legislative Council, there may not be more than 1/3 member of the total member of the Legislative Assembly of the state. The Legislative Council of a state must have at least 40 members in it. These both are correct. If you go through the article, it is mentioned under 170 composition of Legislative Assembly. This is 170, and 170 is composition of Legislative Council. So question is asking about the Legislative Council. The total number of members in Legislative Council of a state having such a council shall not exceed 1/3 total number of members in Legislative Assembly of that state. So it should not be more than 1/3. So it should be less than, Legislative Council should be less than 1/3 of Legislative Assembly, and provided that the total number of members in the Legislative Council of state shall in no case be less than 40. So it should be more than 40 or equal to 40. Now in case of Legislative Assembly, not more than, so in Legislative Assembly there should not be more than 500 members, there should not be less than 60 members. There can be some special provisions, special cases for the states, but this is the written in the Constitution. Next one, which of the following provision is a part of both directive principle of state and fundamental duties? So एक एक करके देखेंगे. Option A, guardian to provide opportunity for education to children, that is mentioned under fundamental duties. Protection of environment, yes, this is under DPSP as well as under fundamental duties. Participation of worker in the management of industries, that is DPSP. Uniform Civil Code, that is DPSP. So here the DPSP is mentioned under the part 4, and the related article are 36 to 51. You can see here these are the articles related to the directive principle of state policy. So this is the organization of village panchayat. 41A, participation of workers in the management of industries. 43B, See 43A, sorry, this is 43A, participation of worker in management of industries. 43B, promotion of cooperative societies. Uniform Civil Code 44, like that. So we have under 48A, protection and improvement of environment and safeguarding of forest and wildlife. Separation of judiciary from executive, that is also important. And the last one is promotion of international peace and security. Now fundamental duties, that is mentioned under 4th A, under the article 51A. There are 11 fundamental duties, and they are to abide by the constitution and respect its ideals and the institution, the national flag and national anthem, to cherish and follow the noble ideas which inspired our national struggle for freedom, to uphold and protect the sovereignty, unity and integrity of India, to defend the country and render national services when called upon to do so, to promote harmony and right of common brotherhood among all the people of India, transcending religious, linguistic and regional or sectional diversities, to denounce practices derogatory to the dignity of the woman, to value and preserve the rich heritage of our composite culture, to protect and improve the natural environment including forest, lake, river, wildlife, and to have compassion for living creature. So this is similar kind of provisions is in DPSP. To develop scientific temper, humanism and spirit of inquiry and reform, to safeguard public property and observe violence, to strive toward excellence in all spheres of individual and collective activity so that the nation constantly rise to higher level of endeavor and achievement. The last one is who is the parent or guardian to provide opportunity for education to his child, or as the case may be, ward between the age of 6 to 14 years. The next one, with reference to the recommendation of the Ashok Mehta Committee 1977 on Panchayati Raj, which of the following statement is are correct. So let's see. The 3-tier system of Panchayati Raj should be replaced by 2-tier system. That is correct. A block should be the first point of decentralization under the popular supervision below the state level. Not block, it was district. It was district. So option A is correct, only one. Here you can see the committee on Panchayati Raj, Balwant Raj Mehta Committee, established in 1957. So they recommended for 3-tier Panchayati Raj system. Ashok Mehta Committee 1977 recommended for the 2-tier Panchayati Raj system. Then the 73rd Constitutional Amendment Act came in 1992, which gave the constitutional status to the Panchayati Raj system. Then let's see recommendation of the Ashok Mehta Committee. So we have seen that he recommended 3-tier Panchayati Raj system should be replaced with 2-tier structure with a district level Jila Parishad and Mandal Panchayat consisting of collection of villages with a combined population of 15,000 to 20,000. So Ashok Mehta Committee that came into 1977. Below the state level, a district should be first point of decentralization. So it should be it is the district which should be the first level of decentralization recommended by the Ashok Mehta Committee. Right to education has been included in the fundamental rights by Constitutional Amendment Act 86, 2002. Let's see some other articles near to 21A, that is right to education. 20 is protection in respect of condition of offences, we have seen earlier. Protection of life and personal liberty, that is article 21. 21A, right to education, that is included through the 86th CA Constitutional Amendment Act 2002. So here education to all children of age 6 to 14 years. Now 22nd, protection against arrest and detention in certain cases. Next one, which one of the following is not correctly matched? Legislative state and member in legislative assembly. So Manipur has 60 member, not 62. So this is not correct, and that's why this is the answer. Goa has 40 member. So Goa is exception, no? So least number of legislative assembly member, how many member can be? 60. 60 is the least number, but here it is below the 60. Uttar Pradesh has 403, that is maximum in any state. Uttarakhand has 70 member in legislative assembly. Let's see some other facts. Manipur has 60, Goa has 40, Uttar Pradesh has 403, Uttarakhand has 70, and lowest number of legislative seats, legislative assembly seats, is in Puducherry, that is 30. Recent election, MP has 234 legislative assembly seats, Rajasthan has 200 seats, Telangana has 119, and Chhattisgarh has 90 seats. We'll move to next one. A joint public service commission for 2 or more states can be established by. So joint public service commission for 2 or more states, that can be established through the parliament. अगर कंसर्न स्टेट के लेजिस्लेचर ने इस प्रोविजन को पास कर दिया है तो पार्लियामेंट कैन रिकमेंड फॉर द अपॉइंटमेंट ऑफ जॉइंट स्टेट पब्लिक सर्विस कमीशन. So it is the parliament who can establish, no? It is the parliament who can establish the joint public service commission for 2 or more states. So this provision is mentioned under Article 315. So here you can see 2 or more states may agree that there shall be one public service commission for that group of states, and if a resolution to that effect is passed by the houses or where there are 2 houses, by each house of the legislature of each those states, Parliament may by law provide for the appointment of a joint state public service commission. Right? The concept of basic structure of the constitution was propounded by the Supreme Court in the case of, so this is a very famous case Anand Bharti versus State of Kerala 1973. Some other cases, Sankari Prasad case 1951, where Parliament said that, where Supreme Court said that Parliament can amend fundamental rights with the Constitutional Amendment Act that is mentioned under Article 368. Ulapnath case 1967, where Supreme Court ruled that Parliament cannot amend the fundamental rights. Like it cannot take away or abridge the fundamental rights. It can add on, but it cannot take away or abridge. Now in Anand Bharti case, basic concept of basic structure has came. So here Parliament is directed, Supreme Court directed that Parliament cannot violate the basic structure. If it is violating the basic structure, so that act will be considered as a null or void. These are some other cases: Indira Gandhi case 1975, Minerva Mill case 1980, Vaman Rao case 1981, Ayar Coelho versus State of Tamil Nadu case 2007. Here SC reiterated its decision on basic structure that Parliament cannot amend basic structure, cannot bring a law which can violate the basic structure of Indian Constitution. So these are some other cases which is mentioned in the option. So we'll see that Chitralekha versus State of Mysore. The government of Mysore laid down the classification of socially and educationally backward classes should be made on the following basis, that is economical condition and occupation. So this was related to the classification of socially and educationally backward classes. Yusuf versus State of Mumbai 1954. In offence related to women, that is adultery, women may be placed in a more favorable position having regard to their social status and need for protection. So that was the judgment came. So women can be put in favorable condition in these cases. Now next one, given below are two statements. One is assertion and other is reason. The 73rd Amendment of Constitution is considered to be a watershed in the history of local self-government in India. That is true, because 73rd Amendment Act gave the constitutional status to the Panchayati Raj or local self-government. The 73rd Constitutional Amendment confirmed the much coveted constitutional status of Panchayat. Yes, this is also correct. So assertion and reason both are correct, and reason is the correct explanation of assertion. Committee on Panchayati Raj we will see. So these were committee. Balwant Rai Mehta committee came in 1957. We have seen that he recommended for 3-tier system. Ashok Mehta committee 1977, he recommended for replacement of 3-tier with 2-tier, and he has given the importance to district level. GVK Rao committee 1985, importance to district level and election to be regular. So these were some recommendations by GVK Rao committee. LM Singhvi committee that came in 1986. So he recommended for constitutional status and judicial tribunal in the state should be established.